Good evening. My name is Stephen Woolfolk. I'm the Director of Programming and Marketing for the Kansas City Public Library. As we continue our online series of signature events, tonight we welcome Kenneth Winn. He's a former state archivist and former Director of Library and Public Services for the State Supreme Court, where he ran a legal history internship program. He's the author or co-editor of a number of books and articles on Missouri political and cultural history, but he joins us tonight to discuss Missouri law and the American conscience. The book features 10 essays that showcase Missouri as both maker and microcosm of American history, touching on Dred Scott's slave freedom suit, Virginia Minor's women's suffrage case, and Curt Flood's suit against professional baseball, among others. His focus tonight is the Missouri Court Plan, a now national model for selecting judges across much of the country that was born some 80 years ago in response to the political manipulations of notorious Kansas City boss Tom Pendergast. Ken, thanks for joining us.
Thank you. The first thing I'd like to say is to thanks Steve for inviting me to speak tonight, and the Kansas City Public Library for hosting this event. I've enjoyed talking to you about Tom Pendergast and how Missouri created the most innovative plan for selecting judges. Steve invited me on the basis of the anthology that he referred to, Missouri Law and the American Conscience. It sounds like something you might want to curl up with in bed right before you went to sleep, or maybe you might think it'd help you get to sleep. But I thought I'd just say a couple words about the book as a whole before I go into to talk about Pendergast. The first thing is that the 10 essays were written under the injunction to the writers that they couldn't use legalese, they couldn't use any words that people who weren't lawyers couldn't understand, and to make them as accessible as possible. So the essays were selected based upon a case that originated in Missouri and then became nationally known or expressed some sort of cultural conflict, which I thought was particularly illuminating. I don't want to sound like a list, but just to talk briefly about some of those cases. The first one begins with, in the territorial period, when Indians were taken into white courts and tried for various crimes. Of course, they were terribly confused, had no idea what was going on. Meriwether Lewis was the territorial governor during a large part of this time, and he wanted all the Indians to have a decent trial before he hanged them. It was William Clark, his old friend's job, to calm him down, Clark would later become the territorial governor himself. So it's that clash of cultures that was about. The second essay is, I don't know if any of you have been to Fort Osage, just outside of Kansas City. It's a historic fort where there was Indian trading in a small military group that was stationed there. There was a guy named George Sibley. He was a fairly young man. He was in his 30s and he was lonely. And so he invited a 15-year-old French girl to come live with him and wrote out a little memorandum of understanding between the two of them. And they got back to St. Louis, and she said, "This is a marriage contract. There's somebody on the frontier, so this has to stand, and you have to marry me." He said, "Oh no, this is not a marriage contract. This is a concubine contract." And what happened is this went into a quarrel where the French lined up with the young girl, and the Americans lined up with the young man, and they slugged it out in court, which was fairly interesting. And then the following essay is, there was a little known slave in a little known case that nobody really cared about called Dred Scott. And what happened is, after the case had been going on for some years, some very powerful white people decided to make this into a big deal. And so they selected a case that was actually kind of ordinary in many ways. Dred Scott had a good case. He was suing for his freedom. He had a good case on his side, but the intervention caused a national uproar, which ended up going to the US Supreme Court, where Chief Justice Taney ruled that slavery was open anywhere in the West. The Missouri Compromise had been unconstitutional, and that African Americans had no rights that a white man was bound to respect. And so the essay tries to show how you went from a small thing and then suddenly became a large national one. When the war began, 3 little over 3 years later, after the Dred Scott case, Missouri was state of the Union, but it was deeply divided. And there was lots of guerrilla warfare to impose their view of how things should be. The so-called, what were called in Missouri, the radicals, took over the court system with military force. It lasted after the Civil War was over. And so they ran things their way for a number of years, and they did this with sometimes over a very resisting population. And so a Civil War historian has written an essay about that. A fifth essay is about a woman named Virginia Minor. She was in a conspiracy with Elizabeth Cady Stanton and a number of other feminists to get herself arrested in St. Louis, which she succeeded in doing by casting an illegal ballot. And her husband was a lawyer, and they took the case all the way to the Missouri Supreme, or the American Supreme Court, US Supreme Court. And in 1874, unfortunately, they found unanimously that, that women weren't qualified to vote, and it would take another 46 years before that day finally arrived. And then a sixth article, women couldn't sit on a jury in Missouri till 1945. They were considered to be unfit for jury service, but Missouri held a constitutional convention. They decided to let women sit on juries, but they allowed a big loophole. And so very few women sat on juries for the next 25 years. And then finally, there was a lawyer named Ruth Bader Ginsburg who took a Kansas City case, and she took it all the way to the US Supreme Court, which said that Missouri could not make any exceptions for women. And finally, Missouri joined by making women to be able to sit on juries, the equivalent of men sitting on juries. There's another essay that not only women, but children, and Missouri treated children very, very poorly. They would probably make Charles Dickens blush, how harsh the standards were. But over time, especially after World War II, Missouri got to be much better at it. And finally, in the recent couple of decades, people now come to Missouri to learn to teach their states how to treat juveniles better. And a professor from the University of Missouri-Columbia wrote an essay about that. Steve mentioned the Curt Flood case. Flood was a 7-time Golden Glove winner for the St. Louis Cardinals, and he had a batting average usually over 300. He was a 3-time All-Star. But when Gussie Busch, who owned not only Anheuser-Busch, but the Cardinals, threw a temper tantrum and he traded a bunch of his players away, he told Curt Flood he was going to need to leave and he was going to become a Philadelphia Philly. Flood objected, sued, and the case went to the Supreme Court. Baseball always had a strange thing. They had an anomaly. They were allowed to do, antitrust laws didn't apply to them. So essentially you played for whoever the owners told you. Now, Flood lost his case, but by a divided vote on the Supreme Court, but the owners were still irritated with him enough that he was denied his chance to be in the Hall of Fame. The last essay in the book is one about Nancy Cruzan's and the right to die case. Nancy Cruzan was seriously injured in a automobile accident, and she was kept alive only with life support. Her family wanted her to die peacefully. But at that point, Missouri State intervened, said there is no right to die. They challenged the family against pulling the life support out from Nancy Cruzan. That case made its way to the Missouri Supreme Court, where Judge Chip Roberts made the decision on a divided court that, that there is no right to die. And that was taken to the US Supreme Court, where Judge Robertson's decision was upheld on a 5-4 vote, saying there was no right to die. So now that's why you have directive. You were asked if you have instructions indicating your directive about what happens to you in case of catastrophe. It was Judge Robertson who wrote this last essay himself. He's very respectful of Nancy Cruzan. He's very respectful of her family, but he is very naughty when he's talking about the judges and the behind the scenes maneuvering. His essay is extraordinarily funny. When is I don't know the last time you'd ever think of, or when you would think of reading an essay and laughing out loud, but his is very witty, and I certainly recommend it for that. Okay, well, I think you've heard enough of the summary, but I've deliberately left out one essay, and that's what I'm going to talk about today. The main difference between what I'm talking about today and what's in the book is I approached this subject through the biography of Lawrence Hyde, who was Missouri's probably most important Supreme Court judge of the 20th century. He got on the court in the early 1940s, and he stayed into the 1960s. But I have taken a part of that out, and that's what I'm going to be chatting now. It's rare for Missouri to be the first to adopt anything, but thanks to a mighty blood sport between Missouri Governor Lloyd Stark and Tom Pendergast, this is what happened. And if you look at the slide that you see right here, that's of course Pendergast on the left, and that's Governor Stark on the right. They started out amiable enough, but they'd soon split. As you can see, Boss Pendergast from this picture looks quite a bit like the boss in setting Stark straight about something. The story is about the Missouri plan is kind of complicated about how it works. And so what I thought I'd do is I would compare a little bit with how President Donald Trump has selected Judge Amy Coney Barrett to serve on the U.S. Supreme Court, and so you can sort of understand better exactly how this rare system works. I should tell you that that I worked with University of Missouri Columbia law students for a while, and I used to always torment them by asking them to explain the Missouri court plan to me. And there are sometimes embarrassment, not one could over the time that I was asking. So it's been in service for 80 years, but it's not especially well known exactly how to do it. Let me begin with the conventional explanation of how the court plan came into existence. And this is what you see on websites, and if you would read about it, probably in the book, and then I'm going to change the history around a little bit later on. But the story goes like this. In 1938, Kansas City political boss Tom Pendergast was very angry about a decision made by Judge James Douglas. And so he decided that he was going to run an election. Judges were all elected, and he was going to run another judge in the Democratic primary against Judge Douglas and get him out of there as revenge for making this decision that he hated. Here's a flyer from Judge Douglas's run for office. So Pendergast recruited this man named James Billings. James Billings, it was from Kennett in Dunklin County, and probably most of you don't know where Kennett or Dunklin County is. It is the county that is the very tip of Missouri's Boot Hill, typical of Pendergast to find people from places far away from Kansas City or outside of Kansas City anyway to do what he wants. So what happened is after he recruited this judge, Lloyd Stark challenged Pendergast and Billings, and the two got in a monumental fight. And at the end of the fight, Lloyd Stark being on the side of the angels, and the evil boss Pendergast being on the side of the devils. He lost. Boss Pendergast was soon in jail for on federal charges of tax evasion. And in the wake of the disgust over this horrible quarrel, we got the nonpartisan court plan when it was passed into law and into the Missouri Constitution in 1940. Let me say that the court plan has always been controversial. The politicians have never liked it. I'll probably say that about 3 more times tonight. The politicians don't like it. And so let's say like stem cell research or the banning of puppy mills or handgun restrictions or now Clean Missouri, it got on the ballot by a statewide ballot by citizen initiative petition. And that was over the opposition of people from both parties. It wasn't really a party issue. It was a politician versus reformer issue. In essence, the plan removed judges from the appellate courts and the lower courts of Kansas City and St. Louis from politics, from electoral politics. Before that time, if you were a judge, you ran as a Democratic judge or you ran as a Republican judge. And so you, like the picture of Judge Douglas here, you put out flyers and campaigned and made appearances and explained yourself to crowds. They had to do it slightly differently to show, they showed a little bit more restraint than traditional politicians, but you ran just like a politician. So the plan takes the politics out of the appellate courts, and by that I mean the Western District Court, which is headquartered in Kansas City, the Eastern District Court, which is headquartered in St. Louis, and the Southern District Court, which is headquartered in Springfield. And what happens is under this new plan, there is a commission set up to tell the governor who he should appoint to the Supreme Court or these Court of Appeals. And so the governor selects 3 members of that commission. They're on staggered terms. The idea was that not one governor could pick everybody, but there are 3 people that a governor picks to be on that commission. And then the Missouri bar lawyers then elect one committee member of from each of those districts, Springfield, St. Louis, and Kansas City, and they make up a commission. The commission is headed on the appellate level by the Chief Justice of the Missouri Supreme Court, who does not have a vote. The Chief Justice can explain, they can offer reasons why that something ought to be one way or another way, or point out things. They're there for institutional knowledge, but they don't normally vote unless there would be a tie. So if Amy Barrett wanted to take a serious pay cut from her current job, she could send in her resume and apply to be a Missouri Supreme Court judge. And usually from 10 to 20 applicants apply when there's a vacancy. If Judge Barrett might be one of the 3 finalists, she was on what was the so-called panel. And then the governor, say Governor Mike Parsons, would then could choose her from that panel. One difference is where the president can go and choose anybody that he wants. The governor can only select one of those 3 people. So the panel is given to him and he chooses one. If Judge Barrett didn't make that panel, the governor could not choose her. If she did, then he would select her. There's no confirmation process. She's automatically becomes a Supreme Court judge. Now, if she is put on the court, she spends at least 1 year until the next major election cycle serving. And then at the end of the year, Missouri voters get a chance. You've probably seen it on the ballot, says judge for retention. You say yes or no. And if 50% of the people say yes, then Judge Barrett would then have a 12-year term to serve on the Missouri Supreme Court. Now, terms on that court are for 12 years. So Judge Barrett's 48 years old. And so when she's 60, she could say, I'd like another term, please. And then the voters could then vote again whether they want to retain her or not. The one difference, though, is you can't serve in Missouri if you're 70 years old or older. So you automatically have to retire on your 70th birthday. So she would only get a 10-year term. That means, contrasted with the U.S. Supreme Court, there would be no Ruth Bader Ginsburg, no Samuel Alito, no Clarence Thomas, no Stephen Breyer, or an Anthony Scalia, because all of them were well over 70. Right now, or were over 70 during their service to the court. So you can only serve for so long. The point of the plan was to take the politics out of choosing judges, or as much as possible, and finding judges that were known for their legal skills, and that their appointment was based on merit, not their ability to flatter politicians. And it was to protect them from people like Judge Pendergast or Tom Pendergast, or an overbearing governor. In 1940, the voters added this to the state constitution by a sound margin, not a landslide, but a sound margin, mostly supported by people from Kansas City and St. Louis. Rural areas were very fearful because they thought the panels and the commissions didn't apply to them, but they thought there's a slippery slope here, and pretty soon somebody's going to be deciding who our local judges are, and we don't want that. So there was a little bit of an urban-rural split between the two. If you don't think that the panels and the selection process means something, you might look at other states. This kind of squishes people in the mushy middle. You get people who are conservatives and some are liberals, but mostly they bunch a little bit more towards the center. And you get a state like Illinois, which doesn't have the plan. If you're in St. Louis, you have the opportunity to watch commercials by judges who telegraph which way they feel about abortion or the death penalty or gun control or whatever. They sort of they don't tell you how they're going to vote, but they're angling for your vote, and they often use a hot button issue to try to tell you what it's going to be like. In West Virginia loves to have fights over Supreme Court judges and Supreme Court judge corruption. A number of years ago, a West Virginia coal magnate gave a lot of money and helped elevate someone to be a judge. Once he did, the judge, instead of recusing himself, took it on as one of his first cases, a suit against a fine against the coal magnate, and he voted to void the $50 million fine against him. So that was money well invested by the coal magnate. In Missouri, that kind of thing would not have been possible. Perhaps some of you read John Grisham novels. John Grisham likes to have, he has sometimes a theme or some sort of political angle that he wants to push. And in one of his books called The Appeal, what he does is he cites why Mississippi is in particular a place where you find a lot of judicial abuse and quarreling about judges and their decisions. And one of the reasons he says that so in the novel, which is you're supposed to leave thinking that they need a nonpartisan court plan. So the conventional story I outlined for you starts a little too late, and so I want to give you a little bit better perspective on it. In the 19th century, the United States underwent massive changes. It became more industrialized, the rise of big businesses. Immigrants were pouring in at unprecedented rates, far, far faster rates than is happening now or even a few years ago. Large cities like St. Louis was the fourth largest city in the United States, became a metropolis. In Kansas City, it began its enormous growth during the same period. And while they did this, they were ripping up the social fabric, changing the political rules. Things just weren't the same, and nobody could get a grip on how to handle a lot of questions that were brand new. And in virtually every big city in the United States, you got a boss. The most famous one is probably Boss Tweed in New York, but if in Philadelphia or Cincinnati or whatever, most cities had a boss. Boss Pendergast was one of the better ones and one of the better known ones. But virtually every place had a boss. Some had state bosses, and rather than say the bad big city, good rural areas, there were courthouse rings in many of the rural areas that were essentially running the show. Politics was very corrupt. It was corrupt in big ways, but it was also corrupt in small ways. To get a big thing done, you paid a lot of money. To get a small thing done, you paid a little money. St. Louis was at that time mostly run by a Republican machine, but that machine was kind of broken. Kansas City was a different story. The Pendergast machine had its origins at the turn of the century. Initially, it was run by Tom's older brother, James. When James died, Tom took it over, and around 1915, he started consolidating power. By the 1920s, he was the undisputed head of Democratic politics in Kansas City. By 1932, he had the ability to decide statewide elections. Pendergast had allies all over the state, but his greatest ability was to have extraordinarily lopsided victories in Jackson County, which is often enough to tip the balance in favor of one candidate or another candidate, depending on who he was favoring. People he liked might get 80% of the vote in an election. He did this in a number of ways with ghost voters, or he had one Democratic election judge said, "These damn Republicans marked their ballots so hard I could hardly erase them." Then there's at this time, many of you remember the famed newscaster Walter Cronkite. He was working in Kansas City on a radio station, and one day during election day, the police came. And they told Walter Cronkite that he was going to vote at a certain poll. So the police escorted him out, put him in their car, took him to a polling place, and told him to vote. Then they took him back to his office. A couple hours later, the police came back and said, "Now it's time for you to vote again." And then they took him out to another place, and then he voted again. Cronkite said he was extraordinarily uncomfortable with this, but he was more uncomfortable with the police and felt not particularly a free agent at this particular time. The point is, Pendergast was very powerful, and if you wanted to go into politics like Harry Truman or Lloyd Stark, you worked or you made your peace with Tom Pendergast. When operating on a statewide basis, as I sort of met with Billings, he liked to find people from rural areas to be his agents. He was a little afraid there'd be a backlash by choosing too many people from Kansas City, so he would find people willing to deal with him that weren't from there. One of the most famous cases came in 1932. That year, the Democratic candidate for governor, Francis Wilson, had a heart attack and died 1 month before the election, which was pretty scary for the Democrats. So Pendergast searched around, and he found an obscure circuit court judge from Platte County named Guy Park. He told the Democratic Party they were going to take Guy Park as their candidate, and so they swallowed hard, and they agreed. And Judge Park won the election and became Missouri's governor. If you remember, this was 1932. This is the landslide that Franklin Roosevelt brought, and he swept all Democrats with him, and he swept Guy Park into office as well. Once Guy Park was in office, a flood of people from Kansas City started coming to Jefferson City looking for work, and they got jobs, and pretty soon wags were calling the governor's mansion Uncle Tom's cabin. So even if you weren't a Pendergast man per se, like Lloyd Stark, who was from Louisiana, Missouri on the Mississippi River, you still had to go ask the boss, which he did. You had to go ask the boss permission to run for office. And if he found you acceptable, then you might get the nod to run. But Pendergast was important not just in gubernatorial politics, but he was also very important in the judiciary. He had long since been choosing Kansas City's judges for some time. And if you wanted your case to be heard, it was best to get a Pendergast lawyer or get a Pendergast lawyer as a co-counsel for your lawyer, which would enhance your ability to get your way. In the conventional story I told at the beginning, it's wrong because it accuses Pendergast of meddling with the selection of a Supreme Court judge in 1938. Actually, he was choosing all of the Supreme Court judges since 1932. There were a few Republican holdovers from the 1920s, but he selected Clarence Burney, Ernest Tipton, Charles Leady, and Lasky Collette. I think I've got somebody here. There's Pendergast's headquarters in Kansas City. Many of you probably already know that. He had a nice house, but he kept his headquarters modest. And there's a people, let the people rule, and notice all the people being trampled by the war horse. And there's Judge Pendergast, it says Missouri Supreme Court, choosing, he's the head of the Missouri Supreme Court. And here's the guy he chose in 1934. His name is Charles Leady. Leady was an interesting guy. He didn't go to law school. He went through an apprentice system. He read law in a law office in Platte City, and he did something more important. He eventually got a law license, but he did something more important. He moved to Kansas City and became a Pendergast functionary. In fact, he ran Guy Parks's political campaign. He told the boss that he wanted to be a Supreme Court judge, and the boss said yes. And so he was put on the ballot in 1934, and he won a stunning victory. And this is the guy that he beat. This guy, his name's Lawrence Hyde. He's from Princeton, Missouri, up near the Iowa border. He was, his brother, older brother, had been the governor of Missouri in the early 1920s. He was a moderate conservative. He was very, very smart, and probably thought he was smarter. He was very talented, but he was a Republican right in the middle of the Depression. His chances of being elected to the Supreme Court were pretty small anyway. But Leady got such an enormous amount of votes out of the Jackson County area that it didn't really matter. The ironic thing is that Lawrence Hyde went to work for the Supreme Court as a lawyer. He ended up having to write opinions for Leady and as well as for other judges, much to his irritation. He would get his revenge, though. He becomes the very first judge selected under the nonpartisan court plan. And here's another picture of Judge Douglas, the man who's at the center of the controversy. After the judges were elected, Pendergast more or less left him alone. He didn't really care what most Supreme Court judges did or their decisions. They were about things that he found boring or didn't care about. He did expect them to do things that he wanted if they involved Kansas City or maybe some special interest of his. But if it didn't touch on those things, the judges were pretty much free to do as they wanted. Unfortunately for Pendergast, he treated politics like a business operation, but he had one very serious personal vice. He loved to gamble on the horse races. He loved it. And not only did he love it, he gambled on races not only locally, but if horses were running in New Jersey or Florida, he would put down cash on these races. The problem was he was a terrible gambler, and he could lose up to $100,000 in a week. Now, he had oceans of money pouring in from his business operations and politics in Kansas City, but he was accumulating a lot of debt. To pay off this debt, he offered to fix an insurance case in the Missouri Supreme Court that had enormous consequences. This case, or cases, because there were related cases, they'd been going on in the courts for 16 years. And it was considered a drag. So some Chicago insurance executives got together. They invited Pendergast to talk to them. They offered him, in the middle of the Depression, $750,000 to fix this Supreme Court problem that they had. Well, the case came before the Supreme Court, but before it was decided, his acolyte, Harry Truman, had become a US Senator. And then as a US Senator, he convinced Franklin Roosevelt to take a Pendergast judge, Cassie Collette, and make him into a US Appeals Court judge. So there was a vacancy. And as was his right, Lloyd Stark appointed Judge Douglas to the court as a replacement for the Pendergast judge. At the end of the day, with the old holdovers, Judge Douglas supplied the vote that ruined the insurance cases for Judge Pendergast. And he was extraordinarily angry. And that's when he decided that he was going to get rid of Douglas. Here's Lloyd Stark. And Lloyd Stark's mistake was he pointed his own guy. He didn't point a Pendergast guy or say pretty please. So when Douglas was appointed and when Pendergast decided to go after him, Stark in turn decided to go after Pendergast. And there was this titanic struggle. So where did Lloyd Stark get his backbone? Why should he want to bang his head against this Pendergast wall? The answer is that Lloyd Stark wanted to be president of the United States very badly. In 1938, he did not know, nor did anybody else, that Franklin Roosevelt was going to run for an unprecedented third term. And he thought by breaking Pendergast, he would get national recognition. He had seen what Thomas Dewey had done in New York. Thomas Dewey broke up the rackets in New York City and New York State, making him into a national figure. And Lloyd Stark thought if he broke Pendergast, he could do the same. So the battle becomes one of proxies between it had Billings on one side and Douglas on another side, but it was really a battle not between these two judges for election. It was a battle between Pendergast and Stark. And one of the interesting things, rather than being necessarily on the side of the angels, both Stark and Pendergast, but Stark did as many dirty tricks as he could think of, and he was busy pulling out the stops as well. So it went on a little bit behind the scenes, but this was a pretty ruthless struggle that involved the purging of massive numbers of government employees and all sorts of things before the time was up. So Stark won the battle, and here's they are slugging out. This is a picture or a cartoon from the St. Louis Post-Dispatch. The very muscular Stark standing up and boss Pendergast on the ground after showing that they duked it out over the judges, and Stark won. And then I mentioned that Pendergast then eventually ran into a different set of problems, and that brought an end to his career. But I wanted to talk to you a little bit about the fight the fight opened the door to the nonpartisan court plan. Where did these ideas come from? Why in the world how do we get a nonpartisan court plan? Did it come out of the blue or what? And so just briefly tell you about a couple of instrumental people. This is a young man. He has a PhD in botany and taught at the University of Nebraska. In 1906, he goes to the American Bar Association and says, there should be merit in judicial selection, and judges ought to be free from politics. This might sound commonsensical to you, but it struck the people at the Bar Association as a thunderclap and made this man, whose name is Roscoe Pound, instantly famous. Roscoe Pound went very quickly from a professor of botany at the University of Nebraska to becoming the dean of Harvard Law School. And he never got his law degree. I thought it was pretty amazing to go from a botanist to a dean of the most prestigious law school in the country, but it happened. Next in line, this is William Howard Taft. William Howard Taft, of course, was president, but he lost his chance for re-election, and he would eventually become the Chief Justice of the United States Supreme Court. But in between that time, he was a Yale law professor, and he wrote an article saying that there ought to be merit selection in our courts. Some of that was secretly aimed at Theodore Roosevelt, who he was quite irritated with. And then there's a third person, and this guy's name is Harold Lasky. Lasky was an Englishman. He'd come over to do some teaching in the United States. And what he did in the 1930s was he figured out how to take all these noble ideas about nonpartisan court plans, and he figured out how to help create the mechanisms to make it work. And he published a famous essay in the University of Michigan Law Review, and people began to think about it in more concrete terms. Now, there's some other organizations that participated along the way that began pushing these ideas as well. Even the American Bar Association, which was pretty conservative back then, began to adopt the idea that there ought to be a nonpartisan court plan. And so what they did is people thought they would try it out, and they went to put it on the ballot in Ohio, in Michigan, and in California, and the voters all didn't like it. And so they turned it down every single time. This is about, and every time they turned it down, the reformers tweaked it a little bit to make it more acceptable to voters. And this is right at the time that the Stark Pendergast feud was going on. And so what happened is, this is Luther Ely Smith. He's probably remembered better today in St. Louis as the guy who had the inspiration for the Gateway Arch and building a memorial to the westward expansion than he is for the nonpartisan court plan. But he and his colleagues got together in a room and hatched out a plan for Missouri to have a nonpartisan court plan. And after they were done thinking about how they would do it, the next thing they said is, we need to find friends in Kansas City. So he went with his buddies to Kansas City, and they found a number of people who were interested in a nonpartisan court plan, including this guy, whose name is Richard Ryder. He was a prominent Republican lawyer who in Kansas City. Later, he'd be head of the Judiciary Committee in the Missouri's Constitutional Convention. He was a very bright guy, and so he decided to join with the St. Louisans, and they in turn went to the Missouri Bar Association and said, we've got this wonderful plan that we want you to join with. And the Missouri Bar said yes. And then they went to the legislature. We said, we've got these St. Louis lawyers, we've got these Kansas City lawyers, and we got the Missouri Bar, and we want to talk about someone sponsoring a bill to change the Constitution so we have non-political judges. And the politicians in Jefferson City not only snubbed them, they were extremely rude to them. They didn't give them a hearing, they essentially tossed them out. They went off, they were in a huff because they had been treated so poorly. And that's when they decided they were going to do a citizens initiative to get this on the ballot. They were successful in on getting enough signatures to put it there. They recruited allies. They got good government groups like the League of Women's Voters and a number of others to join in the crusade to get the nonpartisan court plan. And then, as I said, it passed. The Missouri politicians thought that this court plan was about the dumbest thing they'd ever heard. They thought Missouri voters didn't know what they were doing. So the very first bill number one for the next time that the legislature met was to put the plan back on the ballot and rip it out of the Constitution. And they got it on the ballot, but this time Missourians liked it even better than they did the first time. Judges had a bad image. Some judges had a bad image. A lot of them were treated like their jobs were sinecures. They didn't have to do any work. And this is a cartoon that sort of expresses that once you got to be a judge, you've got to put your feet up. There's a famous story about a St. Louis pharmacist who was recruited by a political machine, and he was made a circuit court judge. It didn't work out very well for him. It was kind of embarrassing. But this poor pharmacist who became the judge became the poster boy for why we should have a nonpartisan court plan. So the politicians still weren't happy with the nonpartisan court plan. So when Missourians voted, as they have to do every 20 years, do you want a constitutional convention? In 1942, they said yes. A convention was held in 43, 44, the same one that gave those women the right to sit on juries. There are people who were elected only to try to rip that court plan out of the Constitution. That's the only reason they really wanted to go. It was a very fierce battle, and speaking of fierce battles, it was almost taken out. The day it came the closest was on January 6th, 1944. That was D-Day, but the plan survived, and the plan has been with us ever since. Once again, the point really is to figure out how to, politics aren't completely out of the court plan. And if you know how the plan works, you know how people sort of sneak in politics through the back door. But it's to make it less political than it was. It was to guarantee that we have more honest and objective jurors than we had before, who didn't run with parties, didn't have to cater to political opinions, and were free to be themselves and make the best decisions that they can. After, in the years following World War II, others followed Missouri. This is known all across the country, all across the nation as the Missouri Plan. If you talk to people in Connecticut and said something about the Missouri Plan, they would know what you were talking about. So gradually states such as Alaska, Colorado, Arizona, and Iowa began copying Missouri's plan. If someone likes the plan, they usually say that 36 states have adopted it in some form. They will point out that Rush Limbaugh's grandfather, also named Rush Limbaugh, ardently supported the plan. Those who dislike the plan say, well, maybe 10 states copied a little bit of it, and then they'll probably quibble about some of those. They'll forget about Republicans like Roscoe Pound and William Howard Taft and Richard Ryder, but they'll tell you that the plan was really written and inspired by British labor socialist Harold Lasky. Since 1945, St. Louis County, Clay County, Platte County, and more recently, Greene County, that is Springfield, have placed themselves under the plan. In most rural areas, people still run as for judge as a Republican or a Democrat. The 1945 debate was the last serious threat to the court plan and on how we select our appeals court judges and the lower ones in St. Louis and Kansas City. But many politicians still don't like it to this day because they feel like they lack the influence they want to get certain decisions made. But the people who hate it change over the years. In the early 1980s, feminists wanted it repealed because there'd never been a woman on this so-called merit court, on the merit courts. By the early 1990s, liberals hated it because Republican Governor John Ashcroft had over 2 terms as governor appointed all 7 judges to the Supreme Court, all Republicans. And then also in the 1990s, there was an effort by some African Americans to repeal it because no African Americans had been on the appeals courts. Those problems have all been somewhat resolved. But today, most recently, People claim that trial lawyers have too much influence over the court plan, and many complain that the courts are too friendly to suits against businesses by trial lawyers. And on it goes, and on the critics go, and will continue to go on, because I don't think everybody is going to ever be completely satisfied with what we have. But whatever you think about the plan, it was the overreach of Missouri's most powerful 20th century politician that made Missouri a national leader in legal reform. And his name was Tom Pendergast. Thank you very much for listening to me. I appreciate it.
Thanks, Ken. So we have a few audience questions, but I want to mention before we get to those, if anybody's interested in purchasing the book, it's available from the University of Missouri Press. The link is in the chat box on the YouTube page, and we'll put it up on the end screen as well when the video ends. And the press is offering a 40% discount for anyone that finds out about the book through this program. The code to receive that discount will be WINN40. That's WINN and the number 40, WINN40. So check it out. It's a fascinating book. And that actually leads kind of into the first question. It's astonishing how much legal history has origins, or at least some significant history in Missouri. Are we unique in that respect, or would you find that in most other states if you just dug a little bit?
Well, I think that the answer is a little bit of both. I think Missouri is unique because it has a clash. It has a couple of things. It has a clash of cultures that produce a certain amount of friction. In the case of people like Dred Scott or the Shelley versus Kramer, which is a famous housing case that outlawed covenants and restricted covenants in housing, these kind of cases tend to come from border states. The courts are more free and accepting of these sorts of cases in the border states than they are, say, in the Deep South. So I think that helps generate a little bit of the cases, especially in regards to race. Some of it is just, I think, the right to die case with Nancy Cruzan. There's been cases out of Florida and other places where right to die was involved. I don't see that especially a Missouri case. There was a lot of manipulation in that case trying to get towards a result, and there were people who with strong religious opinions that were involved. I think Missouri is kind of a crossroads state. They used to call it, Missouri used to be the bellwether state. It picked the right president every year, except 1956, strangely enough, it went for Adlai Stevenson. But every year until recently, it went with the winner in every election. And I think Missouri has a lot, it's a fragment. People tell me when I go to Washington, Missouri doesn't seem like a Southern state, but does it seem like a Midwestern state, like it's Minnesota or Wisconsin or Ohio? Or is it what kind of a state is it? And the thing is, I think it's a state with different cultural regions in it, which helps provoke some of the quarrels. Certainly provoked the viciousness around the Civil War, where more civilians shot each other in Missouri than in any other state, because it's such a mix of people.
It kind of plays into this idea that if you go south in Missouri, it's very much akin to the southern states. In the northern part, it's akin to northern states. Yeah. St. Louis is an East Coast city. Kansas City is a West Coast city. Does that play into it?
Yeah, well, they called St. Louis the last eastern city and Kansas City the first western city. And those people in the Ozarks often have connections with the people who live in eastern Tennessee and Kentucky and some of the areas of North Carolina. In fact, that's where their ancestors were from. And so you get this mix. This Ozark consciousness actually only really occurred in one sense in the early 20th century, when the culture seemed like it was getting pressed on all sides, and the growth of these huge big states. St. Louis was completely dominated by Germans. St. Louis was the only place the Republican Party had in 1860 elected officials. Only slave state in the United States that had elected Republicans in it. It was very dominated by Germans. Kansas City was founded in a different manner, um, um, making an alliance with Chicago in part. Most of the people in central Missouri are from Virginia and parts of the Upper South, and they had a strong commitment to slavery. So you get Missouri is best to be understood as a variety of regions.
We have another question that's curious about the effect that the Missouri court plan might have had on diversity on the courts.
What I think is that the people who make up the commissions and the panels, they may not talk this way, but they're sensitive. They're politically sensitive about issues. And when the pressures began to build, like the need for it became embarrassing when they didn't have a woman who had been a judge. I mean, they followed these pressures. They know what's going on, and so they began looking for whether it's Ronnie White as the first African American to serve on the court or whatever. They know what's happening, and they look to try to find diversity. But a lot of people criticize the court, and they said, "Well, how many African Americans have been elected to statewide office in Missouri?" The answer is none. And yet you have some on the appeals courts. And that's because these commissions have intervened to make sure that African Americans and women make it into onto these courts. There's only been a handful of women who have held statewide office. But now 3 of the 7 judges on the Missouri Supreme Court are women. And there's already been Ann Covington was the first one, appointed by John Ashcroft in the 1980s or about 1990. And so I think the record for women and African Americans on these nonpartisan courts is not great, but it's better than the statewide elections. So you have a better chance of making it onto a court if you are a qualified minority than you'd probably do in elected office. At least that's the way it's been so far.
Okay. That leads kind of nicely into this next question. What prevents pressure from just shifting and being placed on these committee members to send up lists of judges that might have been approved by a political boss? Was it just too hard to pack that list?
Well, at the time that the plan was created, a governor could only serve 1 term. That didn't change until Warren Hearns got the law or the Constitution changed in the 1960s. So these commissioners were always picked by a different governor because they're staggered terms. So one governor couldn't pick all the commissioners, which made it harder to manipulate them. So you get a diversity of opinions, and nobody was supposed to be able to dominate. John Ashcroft came the closest to this during the 1980s, but there's enormous pressure on commissioners. Behind the scenes, if you want to be a judge, what you do is you say, so-and-so is on the commission, who's his best friend? Who do I know that he knows? Or who do I know that she knows? And then they get private calls saying, oh, my friend, Barbara Fields wants to be a Supreme Court judge. She's the smartest woman I've ever met. And I think she's an African-American. I think some diversity would be great. And here's your chance to put somebody on that is both really smart and an African-American. But so these commissioners get lots of private phone calls. And when Judge Barrett, in fact, you saw pictures of it, Judge Barrett goes around and pays courtesy calls on senators to try to get to know me and see what a nice person I am. Quietly, a lot of these people who are wanting to be judge quietly go to a commissioner and say, hi, I just thought if you could just chat with me for a little while and I'd get a chance to know me. They go through an formal interview process when the commission meets, and they're asked questions collectively, but that doesn't stop people from trying to get around to get to a commissioner to try to sway their opinion. There's also things like sometimes you get a commission that has a political opinion or a point of view. And so if you want to force the governor to choose who you want, let's say it's a Republican governor, you offer 2 liberal Democrats as part of the commission and 1 Republican. And the 1 Republican, you know that he's going to choose the Republican if he's a Republican. So you've kind of forced his hand. He's going to choose that one. Most of the time, however, historically, the commission's been sensitive to the governor in power. They know who he wants or the kind of person he wants. And most of the time, they've been very sensitive to that. And so they tend not to play games too much with that kind of thing. But there are behind the scenes. It doesn't take politics out of a court selection. It lessens the politics.
So that kind of answers this last question, but just to add to that, I'll put it out here for you. Considering the influence that lobbyists and PACs have today, was the corruption of the Pendergast era really all that much different than what we see today?
Oh yeah, yes. You saw people who with strong political alliances. And all the judges were very political, and they're less political now. They have to drop their party affiliations. They can't talk about party politics in public settings. Most of the nonpartisan court plan, it usually weeds out the eccentrics. And so or sometimes the brilliant people. You know, we might not get Anthony Scalia, who is very conservative. And we might not get Oliver Wendell Holmes because they might be considered. So what the plan has done is it tends to make the court a little bit more in the center of the political spectrum than it was before, because people clearly identified in the 1920s, 1910s, 19th century, they were clearly identified with politicians and with political causes, and they voted that way. So I'd say the plan gets a B+ and A- or something like that in terms of like fulfilling what people want from it.
Right. So I want to end here. You mentioned a new project that you're working on. Do you want to share that? Are you ready to let people know what's coming next?
Oh, absolutely. I'm thinking about it all the time. I'm writing a history about the Missouri slave trade, which includes some stuff about certainly about Kansas, the Kansas area and bleeding Kansas, but literally Missourians were selling off their slaves, and they were selling them literally down the river, down the Mississippi River, into New Orleans, into Louisiana and Mississippi. The biggest slave market in the country was in New Orleans. We were sending Missouri slaves by the hundreds down further south because you could make so much money. So I'm writing a book about the slave trade and about Missouri's role in it, which was actually pretty important, but it's been largely never quite forgotten, but not well remembered.
I hope you'll come back and talk about that book when it's ready. Hopefully, we'll be doing in-person programs again by then.
Well, I hope so too, and I hope both things are soon. That means the book will be done and COVID will be over.
All right. Thank you very much for joining us. This was great. Again, if you're interested in purchasing the book, University of Missouri Press, the 40% discount is Winn 40. Give it a look. It's a fascinating read. Missouri has a fascinating legal history. Ken, thanks for joining us.
Thank you very much.